Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications exercise number 1 and 2 on the speed of 90 words per minute. Start. So far as the finding on the point of recording of the dying declaration of the deceased is concerned, it is evident that no certificate was issued by the doctor before recording of the dying declaration regarding the physical and mental condition of the deceased. It is also apparent that the dying declaration is not in the question answer form. Legal position for recording the dying declaration is that every endeavor should be made to record the dying declaration in questionnaire format. Sanctity of such type of dying declaration is more in the eye of law than the other form of dying declaration, though there is no any general rule that in each and every case dying declaration should have been recorded in question answer form. Sanctity and authenticity of the dying declaration is attached with its truthfulness. In the present matter, admittedly the deceased, in her dying declaration, did not disclose any fact regarding dowry demand, cruelty, and harassment extended on account of demand of dowry. She simply stated that she received burn injuries due to fire caught her from the lamp. If the last line of the dying declaration is minutely analyzed in context with the other facts and circumstances of the case and also with the sale deed said to have been executed in favor of the daughters of the deceased, dying declaration becomes suspicious document. The last line of the dying declaration clearly indicates that the deceased was under pressure. Prosecution witnesses have stated that no such dying declaration was ever recorded. The trial court has placed reliance on their statements and disbelieved the dying declaration. If, for the sake of argument, the defense version be taken into consideration that a dying declaration of the deceased was recorded, then also for the reasons mentioned above, the dying declaration appears to be a suspicious document. Thus, the court is of the view that the finding recorded by the trial court regarding the dying declaration is based on the correct appreciation of the evidence available on record. No interference is required by this court in the said finding. As far as the letters said to have been written by the deceased and referred to by the appellants to establish the conduct of the deceased are concerned, admittedly, 2 children were born out from the wedlock of the deceased and her husband. Both are alive. In this backdrop, it cannot be said that the deceased was annoyed with her husband, therefore she committed suicide. The trial court has rightly rejected the contention of the appellants on this aspect. No interference is required in the finding of the trial court on this issue also. The trial court finding that letters itself demonstrate the cruelty and harassment caused by the accused is also correct. If she, deceased, was not medically examined earlier regarding injuries caused by the accused, then also the prosecution story on this basis in the bride burning case cannot be doubted. Sri Gupta, learned senior counsel for the petitioners, has advanced his submissions, firstly contending that the impugned order is in violation of the procedure prescribed under the 2006 Act, read with the rules and regulations framed thereunder, inasmuch as principles of natural justice statutorily incorporated in the said provisions have been clearly violated. He further submits that nothing exists to attract the ingredients so as to warrant suspending of the license. He then submits that even otherwise the petitioner has been adversely affected and his right to freedom of practicing a trade under Article 19(1)(g) of the Constitution of India also stands violated. He, therefore, submits that even if the petitioner has approached the appellate authority by filing of an appeal, the same does not take away his right to maintain this writ petition in the aforesaid background when the entire unit has come to a stand still and not only the manufacturing process has been stopped but all others involved with the said unit including laborers and consumers have been unnecessarily been put to a loss. Learned counsel further submits that in the wake of the said background, this petition has been filed and this court should come forward to protect the interest of the petitioner, keeping in view the submissions that have been advanced, particularly the non-fulfillment of the conditions and the procedure having not been followed as envisaged in law. Sri Gupta, in order to substantiate his submissions, has invited the attention of the court to Section 32 of the Act to contend that the requirement under Section 32 is for giving of an improvement notice, and in such a situation the other consequences of at least 14 days' time follows. This is necessary as the petitioner has a right under the 2006 Act, read with the 2011 rules framed thereunder, to seek a remedy in relation to sample analysis and testing and raise objections in this regard. This having not been done and not having been established either by any recital contained in the impugned order or in the order of withdrawal dated 7/5/2015, the procedure has admittedly been violated and therefore even if an appeal is filed the said orders deserves to be quashed. Sri Gupta then contends that apart from this, the provision meant for sampling under Section 47 of the Act has to be applied in terms of the 2011 rules, which makes a provision under Clause 2.4.1 for putting the manufacturer to notice. He has invited the attention of the court to the averment categorically made in this regard in paragraph numbers 25 to 39 of the writ petition, to contend that no opportunity of any kind whatsoever has been given at any stage. In the said background, Sri Gupta submits that the statutory provision having been violated and clearly established, and there being nothing in the impugned order or the order of withdrawal to contradict the same, the writ petition deserves to be entertained under Article 226 of the Constitution of India.